I am Robert Steinbuch. We are back with Steinbuch on Sundays. Heidi, do we have someone on the phone for us? Yes, we do. We have a very good attorney who actually was opposing counsel for me or against me or however one says that. And yet I still like the guy. I'm teasing, of course, because attorneys oppose each other all the time. That's what we do. We get hired to represent our clients. And so we have on the line Brian Vandiver. Brian, how are you?
Good, Rob. How are you, sir?
I'm doing very well. Now, Brian, I wanted to talk with you about a very important issue, and it's about parental rights.
Yes,
so I met someone that you work with who really tuned me in to an important issue going on in Arkansas today, some recent laws that have improved the state of parental rights in Arkansas, but also alerted me to the fact that more needs to be done. By the way, also alerted me to the fact that the Democrat that I'll be running against after I win the primary in District 73 voted against those bills that are now law that improved parental rights. So give us a little on this, can you?
Sure. Absolutely. Happy to do it. Act 604 is the main law that we passed last year, and it was really earth-shattering in parental rights, not only in Arkansas, but across the nation. And what we did is we established a rebuttable presumption in all child custody cases, divorce cases, paternity cases, that there will be an equal 50-50 time-sharing joint custody unless one parent can prove that that is not in the best interest of the child by clear and convincing evidence.
Now, can I interrupt you already, Brian? Unfortunately,
Sure.
as you know, I'm a law professor, and I am I'm challenged when it comes to biting my tongue. I am a bit confused. How is it that it wasn't always the law that the presumption is that both parents have custody of kids? Now, if one turns out to be an axe murderer, we overcome that presumption real easily, don't we? But how are we not starting with the presumption that both parents have custody?
It really is shocking, Rob. And even up until 2003, Arkansas law expressly said that joint custody is disfavored, and not to be awarded. And in I believe it was 2013, the law was tweaked, and so we actually got into the code that joint custody was now favored in Arkansas. But the problem was the courts didn't honor that. They didn't follow that directive from the legislature. And if I encourage you to look at the case Pace v. Pace decided in 2020, where this Arkansas Supreme Court expressly said, look, lower courts, you're not acknowledging this change, which was profound.
It's really remarkable, Brian. I mean, we really need to sort of pause and think about how absurd that is and what kind of crazy leftist ideal, or maybe just anti-family ideal, I don't know what it is, that people would think that the presumption shouldn't be that a child needs both of his parents.
Right. If both parents are fit, good parents, there's no reason why they should not be equally involved in the child's life. And so our primary opponents were the family lawyers, the Bar Association, and the family court judges who came out against this bill, sponsored by my good friend, and I know your good friend, Senator Alan Clark.
Oh, yes.
And in the House, Jimmy Gazaway. And, they just wanted to retain their power in the courts, retain their power in the family court courtrooms, and it was truly astonishing.
Can I be a little cynical, Brian?
Sure.
And I think everything you said is right when you say they want to retain their power, meaning the judges and the attorneys. But maybe it's a little bit more than that. I think that's right, but maybe it's a little bit more. The judges, of course, always want to have the most power. They want to write law, not enforce law. They want to be legislators, not judges. So that's where their thinking is, I fear, for many of them. And I fear for the attorneys, it's even more nefarious. I fear for the attorneys, the reasoning may be, well, listen, if there ain't no presumption, we're going to have to litigate that. And if we have to litigate that, we get to charge more money. What do you think of that?
Absolutely. It's exactly right. And that's what I I said in my testimony in front of the House committee is a lot of these attorneys were opposed to it because it cuts into their bottom line. It cuts into their pocket. And that's the sad case of reality, is that you have lawyers out there this day, presently, who are using families, using children in our courtrooms to their economic advantage. And it's disgusting.
It's exploitation, Brian. It's sheer exploitation of people when they're in their near weakest circumstances in life, and these attorneys are exploiting them, and it gives a bad name to attorneys. You know, I represent a variety of clients for free all the time. I represent right now a rape victim for free. Speaking of child custody, I represent a father trying to regain custody of his child for free. I represent my client in 3 lawsuits that I just talked about to enforce our gun rights for free. I represent 2 teachers up there in Jonesboro who some leftists were trying to railroad out of the school district because those 2 teachers are conservatives. I represent them for free. And yet these attorneys, oh, by the way, if I may mention, my primary opponent in the April 9th, 2022 Democrat Gazette article that I referenced before you joined the show says Steinbuch likes to sue people in court for free. So apparently his plutocrat yacht sailing $30,000 gold watch wearing psyche doesn't like it when the little guy has the same representation of people with money coming out of their noses like him. But back to your topic, as we have been. Why is it that we have so many folks out there who are exploiting people in their toughest of times? I know I'm asking you a question sort of beyond the scope of being an attorney, but you're in the middle of this. You're in the practice. How do these people sleep at night?
I don't know, Rob. It was really shocking to me to contrast my experience in family court to what I do every day in and day out is ordinary civil litigation, where people are treated with respect for the most part. Parties are treated with respect. Family courts, it's a different world, and it truly depends upon which judge. Now, I will say that we are getting some good judges that are changing that, and I think it's more of a generational thing than a party thing. And the younger the judges seem to get it. They understand that children need both parents.
I'll tell you this. I was in family court with my client before Amy Johnson, who I know and is a pleasant person, but I was very displeased with Amy's ruling. We have a previous order that says that the father and his father, we'll call him the grandfather, right, of the child, we're going to share custody, but the grandfather will determine when they get together. It says, and they will mutually agree, but the grandfather houses the child. So when they mutually agree, the father will get to see the kid. So what did the grandfather do? Never agreed. If you never agreed, there's no mutual agreement. Father doesn't get to see the kid. I said to the court, well, that's a breach of the good faith component of that order, of course. You know what Amy Johnson said? Nope. Father doesn't agree. No mutual agreement. Now, come on, man. That's not law. That's make-believe. We're going back to court. Because that was for an emergency order. Now we've got scheduled a hearing on the full motion. And if she rules against us again, we're going up to the Supreme Court. Because we have to enforce parental rights for all parents. This is really just outrageous. Outrageous what is going on here. What more, Brian, do we need to get done?
Well, this is, not just a movement in Arkansas, but this is a national movement. Arkansas was the second state to adopt this presumption. Kentucky was first, but Arkansas was the first to adopt it with a clear and convincing evidence standard. And now we're looking at states. West Virginia joined the group earlier this year. Florida has a bill on Governor DeSantis's desk right now as we speak that will adopt a 50-50 presumption. Ohio has a very good bill that would also adopt a clear and convincing standard. So this is a movement that is happening across the nation. And I think as this issue gets more attention, gets more light on it, and particularly what is happening in our courts, I think we will start seeing a more fair application of it.
Brian, my general election opponent, Andrew Collins, voted against these good bills.
Yes,
he's an
he did.
attorney and a Democrat, and he voted against these good bills. Call me cynical again, but he's not. He works for his family's real estate company, so he doesn't practice in court, to the best of my knowledge. Could it be that Andrew Collins, a Democrat, voted against these good bills because he knows lawyers in the community are lining their pockets with the hard-earned money of people going through this terrible time, and he wants to make sure his buddies in the legal community who are operating in family court get paid as much as they can? Is that possible?
I don't know what's going through Andrew's mind at the time. I can tell you that he was supported, by the Arkansas Bar Association, as the other lawyers in the legislature, for the most part, are, that voted against this bill. Actually, Hudson as well. And so they opposed it, even though I had personal conversations with them. They understood what it did. And, they just were hung up on that clear and convincing standard and didn't want to take that power away from the judges and the lawyers that are involved in the process. And
shouldn't that power be in the power of the people? Shouldn't that power be a function of what the citizens desire as represented by their elected representatives in the House and the Senate? That is the legislature, the most democratic branch of government. Shouldn't that decision be made by the people through the democratic branch of government, not through the effete, elite, ivy-covered columns that surround the courthouses?
I couldn't agree more. Which is why I was involved with the group, Arkansas Advocates for Parental Equality. Patrick Fraley founded that group years ago. His wife, Gina, has been instrumental in getting this Act 604 passed last year. And so I joined them as kind of a legal mind to help them architect the bill, write it, revise it, and then can make the connections in the legislature to get it passed.
I met Gina. She's a very strong advocate, Gina Indelicado. I told Gina that I've had some Indelicado and cheese on a nice hero sandwich. No, it's just a little joke. Okay. So listen, Brian, it was a pleasure having you on the show. Keep up the fight.